Hello, everyone. Welcome to the Safe House, brought to you by the Safe House Initiative. I'm Jeff Edwards, co-chair of the Safe House Initiative and your host for today's podcast. Today, we will focus in on one area that most people don't really consider, which is the longer-term effects of a cyber or ransomware attack. Everybody's concerned about the initial impact of being down, trying to restore operations, plus the overall hectic nature surrounding the event. So today, I wanted to have a frequent speaker in the area of cyber risk to discuss the long tail impacts of a cyber attack. Let me first of all introduce and welcome back to our show David Finz, First Vice President at Alliant Insurance Services in their cyber risk organization. David also hosts the excellent Cyber Insurance Imperative podcast, which I highly recommend listening to. So David, could you give us a little of your background, and in particular, this whole area of cyber risk, as you look at it from all different directions, being with Alliant Insurance Services?
Sure. Thanks, Jeff. And again, thanks for having me back on the program. So as you and I had been discussing offline, I am an attorney by training. Some people consider that an asset. Some consider it a liability. Try not to hold it against me. I entered the insurance industry about 18 years ago. And as is the case with many attorneys transitioning into insurance work, the natural point of entry for that is claims. I still have one foot in claims because that's where the hazards of litigation and dealing with all kinds of liability really comes into play. So that's a natural fit for someone with a legal background. But about 9 years ago, I began to realize that cyber was a growth area, right? It seemed to have some upward potential. And as a result of that, I transitioned more into a broking role. Broking meaning actually, placing the coverage for our clients, negotiating the policy wording, working with them to present their risk to the underwriters in the best possible light. So at this point, I do have a background both on the claims and coverage side, but also as a broker, and also a brief time I spent on the carrier side working on policy drafting, product development. So that's really my background. And here at Alliant, we've really beefed up our cyber capabilities over the past few years. About a year ago, we brought on several folks who have started what's essentially a risk consulting vertical dedicated to cyber. And they help our clients with risk quantification, with incident response planning, tabletop exercises, virtual CISO services, and also getting our clients connected with strategic partners, service providers that can come in and actually help them improve their security posture.
Let me ask you a question, David. Traditionally, how do underwriters and brokers look at the cyber risk arena from an overall perspective? How should they maybe in the future look at cyber risk?
Right, so that's an important question. And the answer, Jeff, is that traditionally, historically, underwriters and brokers have seen cyber as what we call a short tail exposure. Just for your listeners, I mean, when we talk about a short tail, we're talking about that the losses develop relatively quickly after the incident, right? A long tail implies that the time horizon is, much more extended. So when we talk about a short tail cyber exposure, we're talking about the initial days and weeks following the discovery of an incident, right? So it's, oh my goodness, we've had a data breach. What do we need to do? Well, we need to bring in privacy counsel so they can quarterback the operation. We need to bring in forensics to come in and investigate what happened, make sure that we've neutralized the threat, identify the records that have been compromised, and then have privacy counsel come in and make sure that letters go out to these folks, notifying them of the breach, offering them credit monitoring, setting up the call center to do that, right? Or if you're dealing with a ransomware event, is another example, right? Where you find out your files have been encrypted and you have 72 hours to pay the threat actors or else, right? This is where, the crisis management comes into play, and everybody's responding very quickly. And from the insurance angle, those expenses begin to mount relatively quickly in the time following the event. But as I said, the view of this exposure, the view of this risk has begun to change as we develop what is more of a longer tail view of the risk. And there's two reasons for that. One is that when a company has an incident, maybe it's a business interruption and their network is down for several days or a week, maybe it's a ransomware event, there is the potential that some of the business that they've lost won't be coming back on a long-term basis. You could have customers who lose confidence in the business. There's attrition that goes on, whether it's a retailer, if there's some damage to their brand, some reputational harm, and customers go elsewhere. If it's more of a professional services or a B2B type of arrangement, you could have businesses cancel their contracts or not renew them and take their business elsewhere because they no longer have confidence in that company's cybersecurity measures. The other aspect of the long-term exposure is the legal and regulatory. So apart from the fact that there's always been some, class action activity on the part of consumers, and plaintiffs have, a difficult time establishing standing in these cases, in terms of proving actual harm, that hasn't stopped them from trying, that hasn't stopped the plaintiff's bar from trying. But in addition to that, the enforcement authority of the regulators has increased manyfold over the past several years. There are more statutes and regulations on the books, and there are more resources being devoted to federal and state authorities at different levels coming in and enforcing not just privacy statutes, but some minimum cybersecurity controls and some expectations around how data is managed, how incidents are reported, and really increasing the compliance aspect for businesses. So what you see is that months or even years after an event, regulators could come in and investigate a company. There are the obvious legal fees associated with responding to that. There's also the potential for fines and penalties, which sometimes are and sometimes are not insurable. And then there's the cost of complying with any remedial measures that the state authority or federal authority orders, or that the business agrees to rectify whatever gave rise to the security compromise in the first place, right? So these are not expenses that are incurred in the days and weeks following the event. It's a much longer time horizon. And so the underwriters are becoming much more sensitive to the fact, right, that they open a claim and they could be paying out on it for months or even years following the event.
And there's no time frame on the tail, or is there a time frame?
So to be clear, right, the incident has to be reported in the time period in which it was discovered. And I say discovered because more often than not, right, a cyber claim, as we call it, and claim is a loaded term. It could mean a third-party exposure, or it could just simply be a loss, right? Has to be reported in the policy year in which it was made. So, whether a CISO or a managed service provider discovers that there's been a compromise to the network, or, folks come in one day and there's a skull and crossbones on their screen, or even if they get a call from the FBI saying, we've noticed some suspicious activity on your network. However they discover it, they need to report it. Now, once they've done that, right, there are certain aspects of the loss that are time constrained. So, for example, many insurance carriers are now offering coverage for what's known as reputational harm or reputational loss. So this is maybe the network was down for a week, but the customer attrition, the lost contracts, the inability to bid on new business, some of this stuff may go on for a much longer time frame, right? The underwriter is going to want to ring fence that. So they might provide coverage for the losses that can be documented 120 or 180 days after the incident. They're not going to do it in perpetuity. On the other hand, the legal and regulatory exposure, these cases could take months or years to resolve. So, as long as the proceeding arises out of an incident that was timely reported, then the underwriters are going to cover that as long as there are limits in the policy that are left to deal with the exposure, right? Because the legal fees that are entailed in responding to those enforcement proceedings are, essentially a form of defense that is covered under the policy.
Interesting. Do you have a good example of you've been involved with one of these regulatory impacted
Yes.
long tails?
So let's take one that's been in the news recently, right? So
Okay.
we have the New York State Department of Financial Services is one of the leading enforcement authorities in, the realm of financial institutions in the U.S. In fact, many states and even some federal banking regulators pattern
Hmm.
their own regulatory framework after what New York State has done. So just as an example, there's a title insurance company that responded to a journalist report back in 2019 that there was a vulnerability on an app that the title company had developed for users.
Hmm.
That vulnerability allowed users to access documents that were not their own, right? And so potentially exposing millions, hundreds of millions of records to unauthorized access. So upon the publication of this report, the title company promptly disabled the app. They identified the borrowers, the parties that may have been impacted by this. They notified them. They offered them credit monitoring. They also reported the incident, as they were required to do, to state regulators. So in
Hmm.
that sense, they did everything by the book. And yet the state conducted an investigation and found out that there was an internal audit that predated the journalist report by 5 months. And this vulnerability was identified. And unfortunately, even though it was marked as a high priority, it had not been remediated by the title company until the journalist report brought it to light. And so that lag time in failing to take prompt action to plug the hole, so to speak, is what landed them in the regulators' crosshairs. As a result of that, right, in addition to all the costs incurred in responding to the incident initially,
Yeah.
they now had to deal with the legal fees of responding to the state's investigation. They also ultimately entered into a consent order. And this, mind you, this is 4 years after the journalist report, um, paying a $1 million penalty
Hmm.
and agreeing to certain remedial measures that came to light, if you will, as a result of the investigation, things that they could do to improve their security controls. And I want to be clear on this, although, I am a huge proponent of cyber insurance, it doesn't cover everything. The penalty that was assessed in this case is not
Yeah.
insurable.
Yeah.
It actually explicitly says in the consent order that they're not allowed to use insurance proceeds to cover it. Neither are the costs of complying with those remedial measures, because those the underwriters view as a cost of doing business. And things that you need to do to bring yourself up to code are not something that you can pass off to the insurance. You were supposed to incur those expenses anyway. Like, I would liken it to expecting the property insurance to cover putting in sprinkler systems after the fire, right? Because you didn't have them to begin
Yeah.
with. It's like, well,
Okay.
you should have the sprinkler systems in the building to begin with, right? You can't
Right.
expect them now to come in and cover the cost of basic security safety measures that you should have had in the first place, right? My point being that some of the expenses are covered, some are not, but regardless, underwriters are now seeing that months and years after an incident, they are still grappling with the costs of that incident, both in terms of, as I mentioned, the damage to a company's reputation as a result of adverse publicity, and then from the legal and regulatory standpoint, the exposure that results from you knew or should have known, you should have done this, you failed to do that, and as a result of that, what liability do they incur either in the realm of private party litigation, which, again, uh,
Hmm.
plaintiffs have had difficulty establishing standing to sue in these cases. They need to show actual harm, and that's not always easy to do, but it doesn't stop the plaintiff's bar from trying. But then apart from that, the regulators are coming in now and really turning their attention to businesses that, beyond just did you notify us as you were required to do? Because in this case, a title insurance company clearly did that. And we're now getting into, did you abide by the minimum cybersecurity standards that we expect you to have in place, whether it has to do with encrypting data, whether it has to do with deploying multi-factor authentication, whatever the case may be, right? There's certain minimum cybersecurity standards in healthcare, in financial institutions, or when you're dealing with, payment card information that companies are expected to abide by within the framework of their own industry. And then on top of this, now you've got the Securities and Exchange Commission that is more than just dipping their toes into the cybersecurity realm in terms of what they expect public companies to disclose to investors. And then you have the Federal Trade Commission coming in and bringing enforcement proceedings against companies for misrepresenting their security or their privacy controls, because they're claiming that it gives that company an unfair competitive advantage over other businesses who are, playing by the rules. So
Right.
all of this taken together means that cyber has a long tail to it that needs to command the attention of brokers and underwriters so that they understand, right? These are not necessarily incidents that, the network came back online, or we offered credit monitoring, or we paid the threat actors and they gave us the decryption key, and now, we can put this to bed. It's not that simple anymore. There's definitely an exposure in many of these cases, not all of them by any means, but the more significant ones, that goes beyond the days and weeks following the incident.
So you think the long tail is going to be an educational process? It's going to be a longer maturation than the short tail, it sounds like, because people have to be educated at the broker and the underwriter level, and then it has to be educated at the consumer or the policyholder level. Is that correct?
Yeah, well, the underwriters are clearly getting an education on this because they see it in their loss development, right? As they look at their book and they see, wow, this claim is still open from 2019, what do we do, right? As brokers, we need to make sure that the policy is, as we call it, fit for purpose, right? That it picks up in penalties where they are insurable by law, right? Which varies from state to state. And we want to have language in the policy that allows, if there's more than one state's law that could apply to an incident, whatever jurisdiction's most favorable to the insurability of those penalties on behalf of our client. We want to make sure that we have the best coverage we can obtain for reputational harm, right? Again, if I have a client who is facing a slew of customers who have canceled 3-year contracts with them as a result of adverse publicity following an incident, I'm not aware of a market out there that's going to give me 3 years worth of lost revenue for that, right? But I need to make sure that I'm getting the maximum that's available from that market, whether it's 120, 180. I've even seen in rare instances 365 days, whatever the case may be, to try to recoup some of the lost income that results from the longer term effect of damage to a company's brand as a result of an incident. And again, the underwriters want to ring fence this in some way. They don't want it to be open-ended, and I understand that. But as brokers, we need to do our part. Our role in the process is to get the best coverage we can for our client and to push that in the policy wording. And then when the claim comes in, to advocate on their behalf and help them document the longer term damage to their brand.
So, Dave, do you have any final thoughts for our audience, or any kind of a starting point to understand or to act upon the long tail within their own organization? Are there things they can do now, steps they can look into to help minimize the impact?
Absolutely. So like I like to say with clients when we talk about claims, right, there's something called step 0, as I refer to it, right, which is before you have a claim, you need to be able to assess what are the data assets we're trying to protect, right? Who is responsible for making decisions around an incident? How are we going to communicate internally and externally if our network is compromised? And all of this requires developing an incident response plan, right?
Yes.
You don't want to be doing your dress rehearsal on the evacuation of the building while it's on fire, right? So this is something that Alliant has really developed our capabilities to provide to clients, is to come in and actually help them conduct a tabletop exercise, having the relevant people in the room, giving them real life scenarios to work with and figuring out how the decision making is going to play out, who's going to be responsible for communicating, what are employees going to tell customers, how is senior management going to stay in touch when the network is down, and perhaps, my personal favorite is, how does the insurance come into play? What service providers are we going to use? Are they approved under the policy? All of that. And also drafting, if they don't have one, or helping them refresh, if they do, their incident response plan. And we do all of this because we want to make sure that everybody has their marching orders in the unfortunate event that you actually do have a claim, right? It's important to go through these exercises periodically. I'd say at least annually, right? To make sure that when things go sideways, I won't use the phrase that I almost used. I think your listeners know where I was
kind
going.
of have an idea what that might
be.
Yeah.
Something to do with some fan blades. But when things go awry, as they unfortunately sometimes do, that everybody knows how the organization is going to respond. And the best way to do that is to rehearse those plans and those exercises when there's not an actual incident in place. And it's amazing what comes out of it. When we have these tabletop exercises, we whiteboard what we call a parking lot of items, that, action items that need to be followed up after the exercise, and we'll prioritize them. And we'll continue to work with that client to make sure that those issues have been addressed. It may be something as simple as setting up a bank of Gmail accounts to communicate with each other in a time of crisis, or it may be that nobody's actually determined whether the company has a policy about whether they would ever pay a ransom and under what circumstances.
Right. And
who makes that decision, right? So we help clients prepare for that because we want them to be able to manage their risk more effectively. And that's something that we're proud to provide beyond just placing the insurance coverage.
Well, David, really appreciate your time. You're always very insightful, and you always offer great advice. Thank you so much for joining us today on the Safe House, and we'll see you soon.
Thanks, Jeff. Pleasure speaking with you. Take care.
That's our podcast for today. I'm Jeff Edwards for the Safe House Initiative. Thanks for joining us, and remember, be safe, be resilient, and be kind to each other. For more information on the Safe House Initiative, please use your mobile device to scan the QR code on the screen. Send us an email at safehouseinitiative.org@gmail.com, or visit us on our website, safehouseinitiative.org. We look forward to hearing from you.